Is right now in about 30 seconds here, the top of the hour. So maybe it's the start of your work week after a nice long weekend. I hope that's the deal. I'm Robin Meade. We start with breaking news. There's a lot at stake right now for George Zimmerman and Trayvon Martin's family. Everybody's in court as I speak, and we're going to be taking you there shortly. So these arguments can be confusing, but Zimmerman's fate could depend on what is happening today. For more, let's bring in Philip Snyder, who is a criminal defense attorney and is joining us on the phone right now from Miami. So it's an important day for both sides. Nice to have you with us here. What item sticks out in your mind as the most important?
Well, first of all, unless they have a Groupon to Marriott, they're not going to sequester 500 potential jurors. That's just insane. But this really is like a law school exam. There is so much evidence going on today. I think the most important part will be the evidence regarding the character of Trayvon Martin, which, in my opinion, at least from this stage, I don't believe that any of that evidence will come in. But it is going to be something the defense is going to press very hard because it is very telling for the jurors in this matter. You
were speaking previously about, you said, the jury and whether it should be sequestered. So what they're asking for isn't just the jury, but the jury pool?
Insanity. It's not happening. The amount of cost for the state and the amount of inconvenience is just too great. I do think that there's a good possibility that once the jury is picked, that they will be sequestered for the remainder of the trial.
So we mentioned that there are a number of different issues. Which one might be the most difficult here for the judge to weigh?
I think the most difficult issue is probably the voice recognition. It's a very crucial element to this case, especially for the prosecution. I know the defense is trying to get it out, saying that it's not really scientifically proven about this voice recognition. So I think that that's going to be the most heated topic, and that's the one the judge is probably going to have the most difficult time wrestling with.
And isn't there an issue, too, not just about who was screaming here, the voice recognition, as you said, but also if they're going to try to decipher what that person was maybe saying if they were saying something?
Absolutely. It's going to get very messy. I could almost guarantee that both experts are going to have very strong conflicting opinions. I think at the end of the day, the judge is going to have a tough time. They might just say, look, we can't determine. We're going to throw both out.
Now, one of the items, too, is about the jury and taking them to the crime scene. How important might that be, or how key is that to a group of people deciding someone's fate, that they are actually able to see the crime scene? I don't know that I've ever heard that.
It's very important. It doesn't happen in every case because it's a cost and an inconvenience for the court. But I think in this case, it's important. The jury's going to want to see exactly what Mr. Zimmerman is claiming happened at this event. So I do not think it would be unreasonable for the judge to have a little field trip, get on the school buses, bring them out there, and let them see what's going on.
Okay, now you stay with me on the phone here. I think I still have Philip here on the phone. I notice about the judge, about the judge, is that she seems to work pretty quickly in these hearings.
She does. She's very prompt and efficient. Very welcoming.
Okay, did you make anything out about what they just said then about Shelley Zimmerman?
No, it's not unusual. I think that if more issues come up, they'll be readdressed. Clearly, the defense is not shy about going back in front of the judge.
Okay, so that was another motion that the judge just ruled on regarding George Zimmerman and the trial about the killing of Trayvon Martin. Philip Snyder is joining us on the phone, and he's also a legal expert. So we just heard her say that no evidence of his pot use or prior fighting should be mentioned here in the opening statements, as well as regarding his use of drugs or familiarity with guns. Nobody's to mention this in the opening statements, but she didn't appear to take it all out of the way of the trial completely.
Well, here's the thing. None of that evidence was coming in. None of that evidence is coming in. It's a complete red herring. The numbers that they kept referencing, 401, 402, 403, 404, those are the rules of evidence. And they're very, very clear. George Zimmerman did not know Trayvon Martin. Therefore, all this evidence of possible potential violence and drug use, none of that's relevant. There's a complete red herring by the defense. There was some benefit maybe to taint the jury and to prime them, but as far as getting it in, not happening.
Well, but she seemed to say you cannot bring this up in front of the jury, but that it didn't seem to be completely off the table in terms of how the defense could ask about it later on, but not in the presence of the jury. In other words, depending on what the prosecution did, is it completely off the table?
It's possible. It's like that scene in Dumb and Dumber where Jim Carrey goes, so you're telling me there's a chance. There's not a chance. This evidence is not coming in. Again, the judge is leaving the door open, probably just to make sure that she's covering all her bases for a potential appeal. But we're not seeing evidence of his drug use or his prior violence unless something extraordinary happens, and I don't see that coming.
So far today, she has ruled that neither side can mention or show that he had gold teeth prior to this incident with George Zimmerman, about the fights here, that George Zimmerman's wife can be questioned by the prosecution, and they cannot mention school suspensions or drug use of Trayvon Martin. Anything here stick out so far as not being in agreement with the other things that she's ruled on?
No, not at all. I mean, listen, the goal of the defense is to make this inflammatory and make it seem that Trayvon Martin is a bad individual, therefore George Zimmerman is innocent. Conversely, the prosecution's goal is to keep all that evidence out and put all the focus on George Zimmerman to make it seem like he's a vigilante Batman. So this is clearly a game of cat and mouse. Nothing the judge has done has been surprising so far, and clearly she has made it known that this trial will be about the evidence and not about the superfluous facts of possibly Trayvon Martin's extracurricular activities.
Morning. Let's go ahead and bring in one of our legal minds to help us kind of sort out all these decisions. Philip Snyder joins us from Miami. Philip, if I go down the list, it seems like the prosecution is getting almost everything they've asked for. And really, you could sum most of it up that the judge is saying that Trayvon Martin's actions before this shooting, for the most part, will not be allowed in court. What's your take?
Nothing surprising here. A lot of the information the defense has been presenting has been, for the most part, red herrings. Like I've said earlier, there is a benefit to try to prime the jury kind of surreptitiously, but nothing really surprising. I was a little interested that the judge didn't allow the jurors to go to the crime scene to view the potential circumstances regarding the crime, but beside that, nothing really that has moved the needle too much.
And actually, we're going to pick up on that point in just a moment, but I just want to make sure the viewers know what I'm talking about. The judge granted the prosecution's motion to bar Trayvon Martin's school records, things like the fact that he's been suspended, his text messages, prior use of marijuana, any familiarity he had with guns. All those types of things will not be allowed in opening statements. But having said that, is it a jury tactic? I'm sorry, a defense tactic that it's already out there in the court of public opinion?
You know, a very, very good point. Here is the crucial thing that's going on here. The defense is no dummy. They know that none of this evidence was going to come in. But here's what they do know. These jurors may not announce when they are voir dire that they know what's going on with the case. They may say, I took a passive view. But in the back of their mind, they're hearing, Trayvon Martin had gold teeth. Trayvon Martin had drugs. Trayvon Martin did this. Trayvon Martin did that. And that evidence may come in the back of their head when they're making that decision weeks and weeks down the road whether George Zimmerman is guilty of murder.
But what is the defense? How do I put this? Because you want to vigorously defend your client, right? But when you want to put things like that in someone's mind, what are you playing on? I mean, what does it matter whether or not he had gold teeth? What are you playing on? What's the tactic?
There is one crucial element to this case that will be the overriding theme throughout: emotion and inflammatory. You want those jurors to look at George Zimmerman and say, who is that Batman vigilante walking the streets, going out, looking for violence? And then the defense side, you want them to say, who's this individual walking around, committing crimes, being a menace? It is all about jury selection. And if the defense can even get one juror in the back of their head to remember some of the things that have been going on pre-trial, it could be the difference between a guilty verdict and an acquittal.
And to be clear, Trayvon Martin was not we know of committing crimes, but I get your point. That's what the defense is going to try to paint a picture of, for sure. Attorney Philip Snyder is in Miami, listening to what's happening in Florida, kind of helping us put this all in perspective. He's a former prosecutor and criminal defense attorney. Okay. Let's talk about the defense trying really, really hard to keep this jury sequestered. I'm assuming that's because of how much media attention this case has already gotten. What's their thinking there?
You know, I don't see it. Unless there's a Groupon for Marriott for 500 rooms, they're not sequestering that jury. Now, as far as when the jury is actually selected,
yes,
that's more reasonable, because what's going to happen is there's going to be media outlets left and right, and they don't want the jurors to be tainted by some of the information that comes out from people like me. So it's not surprising that they're requesting a jury sequestration, but to sequester 500 jurors, that's just crazy talk.
And you talk about the jury being tainted, but in the weeks and months since Trayvon Martin was shot and killed, this has been in the media so often that this is the challenge in finding a qualified jury.
Absolutely. And here's what's interesting. You know, the prosecution is crying foul. Oh, how can the defense be trying to taint the jury? The first few weeks of this situation, all you heard was George Zimmerman, how he was a bad individual, how he was a racist, how he attacked the child, how he did this, how he did that. This is just the defense's opportunity to play a little tit for tat. So I certainly understand why the prosecution wants a gag order and wants this to stop. But as far as the defense goes, it's full steam ahead.
So you're saying that this is something that both sides do.
Absolutely. What's good for the goose is good for the gander. Fight it out. Make it happen.
But does it really serve? I don't know. Does it serve the legal process well when that's how it's played?
Sadly, it does not serve the legal process well, but the reality is that this case is won and lost on jury selection, period. Everything else that occurs after the fact is not important. Strike that. It's important, but it's more important on who those 6 people are that are looking at George Zimmerman and looking at the prosecution and looking at the defense. The case is won in jury selection, and the defense is going to do everything they can to make sure they have the best jury on that panel.
Okay. Let me ask you one more question. I was intrigued by Mark O'Mara asking that the jury be brought to the scene of the shooting. How often does that even happen?
It doesn't happen often, but most cases aren't Trayvon Martin versus George Zimmerman. Put him on a Greyhound bus, get him out there, let him see the crime scene. I see nothing wrong with it. I was a little surprised that the judge made the ruling she did, but it doesn't move the needle much either way. They can show pictures. There's other ways to get that information in.
We're going to bring in Philip Snyder, attorney who's been helping us sort this out. Philip is in Miami. So, Philip, our understanding is that there is an attorney on the stand right now being questioned by George Zimmerman's attorney, Mark O'Mara. He is an attorney for the IT director for the state, and the defense alleges that the state did not turn over all of the evidence, didn't turn over all the pictures and texts from Trayvon Martin. That is correct, right? That's what they're discussing at this moment.
The first bomb by the defense.
Okay.
This is, it's interesting. They wait until the last minute. They throw this bomb, this secret bomb, and now what it does is it seems as if the state, through the IT department, is hiding evidence. They're withholding evidence. What does that do? Well, it tries to undermine their position, and it tries to tell the court, look, Judge, we're doing everything we can. The state, they're the bad ones. They're the ones that are hiding evidence, and they're hiding evidence because Trayvon Martin has a lot more in his past, and they're going to use that later to try to mold and manipulate the judge into more favorable rulings. A big bomb by the defense.
Okay, and the defense is also asking for a judicial inquiry into this. So what's next in the process?
Well, you have to remember, throughout this whole thing, the defense is putting little snippets in because they're trying to save a potential appeal. Okay. So what they're doing is they're just trying to, set the groundwork. They're asking for a judicial inquiry. They're seeing, hey, state attorney's office, did you know of this? And did you withhold this, what they call Brady evidence, which is any evidence that they have to disclose that may be exculpatory towards the defense. And if more evidence comes to light, it could lead to more severe penalties and repercussions for the state.
Well, I was going to ask, what could a remedy be in this case if the judge finds this, in fact, is what happened? What is the remedy going forward?
Well, the remedy, particularly for this, is probably somewhat insignificant. But when you add everything up in its totality, it could, and I'm not saying it will, but it could potentially lead to a dismissal at some point, obviously without prejudice. But at this point, it's just building, trying to see what information the state's withholding and how it's going to affect the defense.
And at this point, it seems to be a credibility issue, is what you're saying as well.
It goes towards the state's credibility in the prosecution of this matter.
Okay, thank you very much, Philip. That's why we need you. Sit close. We're going to need you again to talk about this real quickly. Philip, what's your reaction to that little exchange?
So I understand, but we did not.
Pretty common.
Yeah.
If you're in the court system, that's not unusual. The defense attorney, and for that matter, the state, they're always going to want to get that little jab in. Attorneys think they could talk anyone out of anything. So the judge made her ruling. She was firm. She said,
she had all of her dates.
She actually gave a very good reason.
Yeah.
I mean, she said, you have this date and this date and this date and this date. I gave you all the time. There's all these jurors here ready to go. We're moving forward.
All right. And also now it makes it even more clear why where Mark O'Mara was going with the allegations that the state is not turning over evidence. He's trying to lay the groundwork that I cannot be prepared.
This is not his first time to the rodeo. He was setting the stage. He knew he was going to ask for that continuance, and the judge denied him. It's the judge's discretion. She did what she wanted to do, and it's time to play ball.
Okay. Right now we're going to talk to Philip Snyder, guys. Is that the plan? Philip, there you are. That's how they answer, as they pop you up on the screen for me. That's good. Okay, so let's talk about it. This is an extremely significant hearing. It's the last one before the trial gets underway on June 10th. But I guess if you don't watch trials, a lot of this seems very, very dramatic. But these types of tactics to get a delay and to say the other side isn't doing what they're supposed to be doing, is this pretty much par for the course?
Very par for the course. I remember as a prosecutor one time, there was a witness who wasn't available, and I asked the judge, and I asked the judge, and I asked the judge, and she kept saying no, no, and finally she said, I'm going to hold you in contempt if you ask me one more time, and that was it. So Mr. O'Mara did a good job. He tried. He set the stage. It is what it is. We're ready to go. Let's play some ball.
Okay, let's talk about the significant things that have also been ruled on, besides the fact that the continuance was denied. There was a lot that the defense had wanted to bring in about Trayvon Martin, and it seems that the prosecution won on just about every count. The fact that his school records will not be brought in opening statements, text messages, any familiarity with guns, all of that seemed to go on the prosecution's win column. Is that something that you expected?
You know, to the layman, it seems that the prosecution is getting these big wins and the judge is biased towards the state. That's not true at all.
Okay.
99% of these were already decided beforehand. Any person who studied one day of law school would know that these were going to be denied. There was a very good reason why the defense brought forth all these and made it such a spectacle. But as far as getting it into trial, it was never going to happen.
And what's that reason?
Well, the reason is that they want people to hear this. They want the normal viewer, the potential juror, to hear what's going on. Because when those jurors are paneled and they ask them questions such as, do you know anything about this case? And they say no, there is a chance in the back of their head they remember watching me on CNN and saying, hey, remember when he had gold teeth, or he was accused of smoking marijuana, or he had text messages? They might not say it, but they might remember it. And that juror might be the difference between an acquittal and a guilty verdict.
Okay, and a point that I think is worth reiterating is that it was ruled that these things cannot be brought up in opening statements. That doesn't mean the defense can't find a way to bring it in during trial, right?
It's possible. I mean, the judge made it pretty clear. This isn't coming in. And what I found to be interesting is that, you know, he's accused of smoking marijuana. Now, I've seen pictures from Grateful Dead concerts. I don't remember anyone being violent and throwing punches and taking bats. I didn't know marijuana was such a hot topic issue, but hey, that's for another day.
It is for another day, Philip. Maybe we'll talk about it on another day. Another issue that the judge has not ruled on, that she said that she would still consider, is the defense's request for this the jury to be anonymous, to be sequestered. That's a pretty high bar to get a judge to sign off on that, is it not?
It is. I think in this case it may be warranted. It's entirely in the judge's discretion. But I think with all the publicity and all the media attention, it might not be unreasonable for the 6th juror or the 7 jurors with the alternate to be sequestered. I do not think it is reasonable for the entire panel of 500 jurors to be sequestered. That's just not happening.
It doesn't even seem it doesn't seem logical. It doesn't seem possible in this day and age for that to happen.
No, you need a lot of Greyhound buses and a lot of Marriotts. I don't see it happening. Definitely not on the state's dime.
And also another topic that was debated today, the prosecution wanting a gag order in this case. Isn't it a little late for that? And they've repeatedly asked for this. Let me say that.
Here's the thing. What's good for the goose is good for the gander. The first few months, all you heard about was George Zimmerman, what a bad person he was, what a racist he was. He was Batman. He was the vigilante. Now the defense is just playing tit for tat, and now the state's crying foul. I don't think it's going to happen. That gag order is not going to be issued.
All right. So it seems like they've gone down a list of really significant rulings so far. I think, tell me your take on this case going forward. There seems to be a lot of emotion with a case like this, but I would imagine any case where someone has lost their life, that is the case. But this seems to have so much writing on it that I think this calls for us as a society to really rise to the occasion to get a fair verdict in this trial. It's a challenge.
You know what? Emotion's the name of the game. And those jurors that are selected, that's what they're going to be feeling. They're going to be looking at George Zimmerman and they're going to think, do I like this guy? Do I think he could have done this? Do I think he was acting in self-defense? And emotion is going to guide them. They're going to make it seem that it's about the evidence, but I'm telling you, it's about the emotion of the juries and whether they sympathize for the victim or whether they sympathize for Mr. Zimmerman.
Wow. How often is that the case? Because we're dealing with jurors, we're dealing with people that it often does come down to emotion mixed in with the evidence.
You know what? They're people like anyone else, and they will tell you, when asked the question, you know, the key question is, are you going to be fair and impartial? And that's kind of a silly question, because who's going to say no? They shake their head and go, of course I'm going to be fair and impartial. But deep down, they have their own emotions, and they have their own prejudices. And that's not going to be fully disclosed. And what the defense is going to do and what the state's going to do is try to bring out that information. But even something as simple as in the back of their head that they might believe that Trayvon Martin had gold teeth or smoked marijuana, that actually could be the difference, which is quite scary in a case of this magnitude.
It really is. Philip, as you're talking, we're seeing pictures of the family attorneys for Trayvon Martin's parents. We see his mother, Sabrina, there. His father might be there, but I can't quite get a shot from behind. But there are his attorneys and his family who have been there every step of the way as the trial gets closer and closer.
And you know what? That's by design also.
Go ahead,
I'm sure they want to be there, but they want those jurors to look at them and see the tears and see the emotion, the same way that the defense is going to want to bring forth the fact that George Zimmerman's a good individual. Those individuals are going to be the beacon of Trayvon Martin, and the state's going to hope the jurors occasionally peek over and see an individual crying or wiping their eye or shaking, because that might be the difference between a guilty verdict and an acquittal. It's amazing how many emotions are involved, and even the slightest thing could tip the trial to the defense or to the state.
Wow. When you put it that way, you're right. There's so many factors in the air, and it doesn't always just come down to evidence. But you know what? Evidence is viewed from different perspectives from everyone, depending on what baggage you bring into the courtroom. And I suppose it's also about making sure that George Zimmerman's attorney wants people to understand that George Zimmerman's life has value. The prosecution wants everyone to know Trayvon Martin's life had value as well. And you play on people's emotions to make that case.
Exactly. And just like a good steak restaurant, you get the bread, you get the butter, you get the asparagus. But what are you waiting for? You're waiting for the steak. And the steak is when George Zimmerman testifies, and that's going to be the difference between whether he's cuffed or whether he walks right out the door.
Okay, Philip, we appreciate your insight, having been in the courtroom so many times. Let's bring in attorney Philip Snyder from Miami, who's been listening as well. Philip, basically what Benjamin Crump is kind of saying is, I told you so, that everything that you heard released about Trayvon Martin last week is basically what the judge says you will not hear about in trial. And the way Ben Crump described it is, it's not necessarily evidence, that there's a very particular standard for whether or not something is evidence, right?
Well, here's what he's saying, and it's pretty funny because you now have the state at the beginning putting forth all this information for viewers and potential jurors to hear. And then the defense does the same thing. And now Benjamin Crump's doing the same thing. It's all cat and mouse. What I found was interesting is he kept saying that it's not relevant. It doesn't mean it's not true, however, but more importantly, just because the judge doesn't think it's relevant and that the laws of evidence clearly say it's not relevant, it doesn't mean that John Smith or John Doe or Jane Doe, whoever that juror is, may again have it in the back of their head and they might find it to be relevant. So this is all very planned and contrived. The state's doing what they have to do, the defense doing what they have to do, and Mr. Crump is doing what he has to do to sway the public opinion.
We've heard a few legal terms this morning. Most recently, we heard the term Brady evidence from Benjamin Crump. Earlier, we heard the term Richardson hearing. Could you explain what those terms, what that's about?
Well, Brady evidence mean that any evidence the state has in their possession that could be exculpatory, they have to disclose to the defense. For example, let's say someone brings a gun and says, oh, this has Trayvon Martin's fingerprints on it. The state can't decide whether they want to disclose that information to the defense. They have to disclose that information to the defense. Now, with a Richardson hearing, what that means is that sometimes if evidence is presented and one side or the other feels that it was not properly disclosed by either side, they have a hearing called a Richardson hearing to determine the admissibility of that evidence and whether other procedures or precautions need to be taken to make sure a fair trial is given.
Okay, there was so much ground covered in this hearing this morning. And also just a moment ago, we heard from the brother of George Zimmerman, but George Zimmerman's attorney was not there for that impromptu press conference. Stick around because I want to ask you, Philip, on the other side of the break, about that, about a coordinated message on behalf of George Zimmerman. So stick around and we'll talk about that on the other side of the break. I was speaking to attorney Philip Snyder from Miami to kind of help us analyze everything that's been happening in this hearing this morning. And Philip, when we heard from George Zimmerman's brother, he basically said what you would expect a brother to say. He spoke about his brother's character. But I found it unusual that Mark O'Mara, none of George Zimmerman's attorneys were there with him. I would imagine that his attorneys want to be able to control the message that comes out about their client because this has so much been tried in the court of public opinion.
Well, maybe it's because I'm a big Seinfeld fan, but every time I hear George and when I heard that statement, the first thing that came to mind was yada, yada, yada.
Why do you say that? Why do you say that?
That meant very little to me, that
Okay.
statement. He's just talking, the fact that Mr. O'Meara and some of George Zimmerman's defense attorneys were not present likely means that it was a rogue statement.
Right.
They may have been aware of it. They may not have been aware of it.
That is to my point, is that there's so much on the line. That is exactly my point. There's so much on the line. Might they want him to stop speaking unless they know what he's going to say?
Listen, everyone wants their 15 minutes of fame. Who knows his motivations? Who knows if they're pure or impure? Whatever it is, there's going to be a lot of people coming to light that are saying, I know George Zimmerman, he's a good guy. I know George Zimmerman, he's a bad guy. The fact that Mr. O'Meara wasn't involved in the statement, again, leads me to believe that it wasn't coordinated with the defense team, and it's likely an individual who's just trying to get in front of the camera, get his 15 minutes of fame.
Okay, and you didn't hear anything particularly damaging in what he said?
Damaging? I found it to be nothing.
All
I found
right.
it to be just yada, yada, yada.
Okay, Philip, thank you very much. And
again, as far as the 500 or 600 jurors, that's not happening. Unless they have a group on at Marriott where they're going to bring 500 people, they're not sequestering the entire veneered panel. As far as the 6 jurors and the alternates, that's a strong possibility. They do not want the people that are selected to be influenced by all the outside media attention. I would not be surprised if the judge sequestered the jurors that are actually selected and the alternates.
Okay, so that is one thing that the judge did not decide on today. So there's actually going to be another hearing on that and possibly another hearing. So 2 more hearings before this trial gets underway. June 10th, and it is going to happen June 10th, even though the defense did ask for a continuance. That is a decision the judge made today. Philip Snyder, we have appreciated your help so much this morning getting through this hearing.
It was a pleasure. Thank you so much.
Absolutely. And we will certainly need you again, so stay close. We appreciate it.